Hello, everyone. Welcome to this CCPL book talk. Thank you all very much for zooming in from wherever you are. I am Alex Schwartz. I'm Deputy Director of the Center for Comparative and Public Law at the University of Hong Kong, Faculty of Law. I am very fortunate today to be joined by Professor Joel Colón-Ríos of Victoria University of Wellington Faculty of Law, where he is also a Director of the New Zealand Center of Public Law. Professor Colón-Ríos is a distinguished scholar, the author of numerous publications in constitutional theory and comparative constitutional law. In addition to the book that he is speaking about today, he is also author of Weak Constitutionalism, Democratic Legitimacy, and the Question of Constituent Power, published with Routledge. And Joel joins us today to speak about his recent book, Constituent Power and the Law, published with OUP in 2020. This book is, I think you will find, it to be an important contribution, not only for the conceptual history that it so eloquently renders, but also because of the implications it has of urgent interest to scholars in comparative constitutional law at the level of theory and also in practice, in the use of constitutional referenda, in judicial interventions relating to the constitutional amendments, in mass protest movements, even in populist politics and so on. There are numerous implications to be drawn from it. Joel will speak about the book for about 25 minutes to 30 minutes, and that will be followed by questions and discussion in virtual attendance. So I will pass things over now to Joel, and thank you very much. You can go right ahead, please.
Thanks very much, Alex, for that kind introduction and an invitation. And thanks to all for being here today. Thanks also to Winnie, who helped us with the organization of the seminar. What I wanted to do, as Alex said, was to tell you a little bit about my book, and then focus on certain aspects of chapter 10, which is the last substantive chapter, and naturally the one that attempts to bring everything together and transform it into a final argument, which I hope tells us something new about the nature of constituent power and about the limits of the power of a constituent assembly. I think I should begin, even if only for completeness, by very quickly saying something about constituent power. So constituent power, as you know, is the power to create new constitutions. And since the French Revolution, it has been generally attributed to the people or to the community or to the nation. Now, one key feature of constituent power is that it has been traditionally understood as an unlimited power. So it's a power not bound by any form of positive law, so that it can be exercised even in violation of a constitution's amendment rule, for example, through an informally convened or technically illegal or extra-constitutional constituent assembly. Then the idea is that after a constitution is in place, the powers that emerge from an exercise of constituent power are bound by whatever procedures and limits the constituent subject has created, and then they are called, according to the language generally used by the theory, they are then called the constituted powers, and then they include, for example, the legislature, the judiciary, and the executive. So those powers, those constituted powers, are regulated by the Constitution itself and find in the Constitution a limit. But the idea is that the constituent power itself does not disappear with the creation of a constitution. That at least is the traditional view, that it continues to exist, perhaps in a dormant stage, waiting to be exercised sometime in the future. So my book is about the relationship between constituent power and the law. And what I did was to explore the ways in which that relationship developed through constitutional history since the 18th century. And I make a particular emphasis in France, Spain, and several Latin American countries. Now, one of the main contexts in which the theory of constituent power has become legally relevant, although not the only one, as I show in the book, is in the context of the doctrine of unconstitutional constitutional amendments. And I'll just talk just for a minute about that, just to give you an idea of the way in which constituent power, that a concept that is usually associated with extra-legality and so on, can play kind of like a juridical function. So according to some formulations of the doctrine of constitutional amendments, the power to amend a constitution according to its own rules is a constituted power, and therefore cannot engage in the creation of a new constitution. So courts that have adopted that doctrine, for example, courts in Colombia and in a certain way in India, have said things like, for example, if the entity authorized to amend the constitution attempts to pass an amendment that alters the constitutional order in such a fundamental way that it really amounts to the creation of a new constitution, then such an amendment is unconstitutional, even if its adoption meets all the relevant procedural requirements associated with the amendment rule, because it would be an instance in which a constituted power, the power to amend the constitution, is acting ultra vires, so invading the exclusive jurisdiction of the constituent subject to create new constitutions. But then that's the amending power, of course, as a constituted power. But again, the idea is that the constituent power itself is subject to no procedural or substantive limits whatsoever, even if substantive legal limits whatsoever, even of course it could be subject to, say, political or moral limits, of course. Okay, so that's sort of what constituent power is. And as I said before, what I try to do through the book is to kind of trace the relationship between constituent power and the law. For example, what I just talked about, that the doctrine of constitutional amendments would be an example of that relationship in the contemporary world. But in the book, what I do is kind of go back and see how legal discourse have referred to constituent power in order to sometimes limit, sometimes justify political power, or particular acts of political or exercises of political power. So now I will talk a little bit about chapter 10. So chapter 10 of the book is, in a way, the most normative chapter of the book, and at the same time the less historical chapter, because it's really a constitutional theory chapter. So what it does, it builds on a distinction between constituent power and sovereignty, which is developed at length in chapter 9. So what I will do, I will begin by explaining that distinction. But before that, I should make the following disclaimer. So what I will do, and what I did or tried to do in chapter 10, is to distinguish between the concepts of sovereignty and the concept of constituent power, not by offering a new formulation or definition of those concepts, and that one could do that, and one could try to kind of present sovereignty in a new light, for example. But I wasn't trying to do that. What I was trying to do is to sort of try to distinguish between them using the very conceptions that have been dominant in modern constitutionalism. So the idea is a little bit to say, if we take the way in which sovereignty and constituent power have been understood in constitutional theory, we should in fact be or have been distinguishing between these two concepts, even though we haven't. In fact, the distinction itself between sovereignty and constituent power is not new. It was already present in CS, who actually, if you read CS, you will notice that he only used the word or the concept or the term sovereignty in a negative way. So when he was referring to the kind of power that should not be exercised in France. And it's a distinction that it was also present in a certain way in Schmidt, in Carl Schmitt's work, but it's a distinction that I think has been largely forgotten. That is to say, today, constituent power is typically defined as a sovereign power. And in fact, I think Alex mentioned Weak Constitutionalism, another book that I wrote a few years ago. And I think in that book, I haven't checked, but I'm sure I, at some point, described sovereign constituent power as a sovereign power. And I think that was probably the wrong thing to say. So because constituent power is typically defined as a sovereign power, what happens then is that when an assembly, a constituent assembly, is called to exercise constituent power and to adopt a new constitution, then the constituent assembly is then understood as a sovereign assembly. In fact, and as you know, in English constitutional discourse, people sometimes refer to Parliament as a constituent assembly in permanent session. I mean, or used to do that. I think it doesn't happen anymore. But in, say, in the 19th century, some authors, famously de Tocqueville, for example, they said the English Parliament is like a constituent assembly in permanent session. But the reason they said that was due to the fact that Parliament is sovereign and can therefore adopt any ordinary or constitutional laws it wants. Now that view that sovereignty and constituent power are kind of the same thing, or that if you exercise constituent power, it means that you also have sovereign power, is also reflected in the famous decision of the Colombian Constitutional Court about the powers of the Constituent Assembly that drafted the Constitution of 1990, but is also present in Latin American jurisprudence more generally, and probably in most views about the nature of constituent assemblies. So what I try to do in chapter 10, and what I will try to do in the rest of the presentation, is to challenge that view, to argue that constituent power and sovereignty are two different things, and then I will tell you why this distinction is important, or at least why I think is important. So the first thing that I think I need to do is to give you some kind of definition about what is sovereignty, or more accurately about what has been traditionally meant by sovereignty in discussions about constitution making or constitutional change. So I think in those contexts, what is meant when people talk about the exercise of a sovereign power is a power that can be used to transform any will into law, any sort of will into law. So it's the power to transform into law, for example, a legislative, a judicial, an executive will, or a constitution changing or constitution making will. And to do this, of course, without necessarily following any established procedure. Now, historically, the ability to exercise that kind of power, what I'm calling now sovereignty, has been linked to extreme situations, to emergencies where there is a threat to the very existence of a state. In that type of context, reactionaries like Schmidt himself or Juan Donoso Cortés in Spain in the 19th century, Donoso Cortés, they argued that whoever was able to bring society to order in that kind of extreme emergency scenario was the sovereign. It could be an assembly that was sovereign, could be an individual. What mattered was that sovereign entity, whatever it was, had the ability to bring society back to order, and because of that, they should be considered sovereign. Now, that person or entity would be, Schmidt, for example, said, and Donoso as well, Donoso Cortés as well, would be in a position to the same position of that of an absolute monarch. So it would do would be able to do whatever is needed to protect the state, even creating a new constitution, but not only creating a new constitution. It could just take any sort of repressive measure or law creating measure that it wants. It could exercise judicial powers. It could suspend parliament. It could change the composition of the courts. And it could also adopt a new constitution. Now, despite the dangerous and anti-democratic character of that perspective, I find it useful because what it does, it allows us to realize, I think, that constituent power is an element of sovereignty. So it's the power to create a constitution or to alter an existing one in fundamental ways, but it's not the same as sovereignty. So sovereignty seems to include the constituent power, but it is more than that. So that is my first point. That constituent power is sort of an element of sovereignty, but sovereignty is much more than constituent power. Now, if one asks who the sovereign is, the answer that one usually would give today is something like the people or the community or something like that. And in some places, of course, what counts as the people or what counts as the community, that will be an issue, but let's for the moment leave that aside, and we can come back to it later if you wish. So the problem, of course, is that even if you agree about who is the people, let's say you agree, well, the people are all the citizens that are subject to this constitution. Even if you are able to take that sort of sometimes simplistic, what could be seen as a simplistic view, if you do that, still you will have a problem, which is that, of course, that people cannot meet and exercise its sovereignty directly, and the traditional constitutionalist view would say that because it cannot do that, it would act through particular state organs. So it authorizes a legislative assembly to create ordinary laws, a system of courts to adjudicate disputes, and so on. But then this also applies, I think, to those occasions when it becomes necessary to adopt a new constitution or to change the existing one in fundamental ways. So in those cases, the sovereign people or the sovereign community delegates the exercise of constituent power to a special assembly, to a constituent assembly. But, and this is the second point that I want to stress, in the same way that just by being authorized to exercise the legislative power, a legislature does not become sovereign. It does not become an entity with the authority to transform any will into law. A constituent assembly, by being tasked to exercise constituent power on behalf of the sovereign, does not become a sovereign entity. Now, if accepted, this view, which is I think it's not really a controversial view, I hope, but maybe it is, you will tell me soon, but it would have several practical implications. First, unless authorized to do so, and unlike it has happened many times through constitutional history, a constituent assembly would lack the power to adopt ordinary laws or to intervene with the constituted powers because it is not the sovereign. Since the assembly is not sovereign, it must only complete the specific task for which it has been convened, which will normally be the creation of a constitution or even the drafting of a constitution. The second implication has to do with the nature of the authority of a constituent assembly. And my point here would be that a constituent assembly should be understood as always acting under a mandate from the sovereign, and that such a mandate must be understood as legally binding, as an imperative mandate. And what I do here is to try to rescue an idea that in chapters 2 and 5 of the book, I associate with Rousseau. And that idea can be summarized as follows. So sovereignty belongs to the people or to the community, understood not as an abstract entity, but as the multiplicity of individuals that live under a juridical order. Now, that view, and as I said earlier, of course, sometimes it would be into, the problem would be that you don't know who that multiplicity of individuals are. But as I said, let's leave that problem aside for a moment. Now, that view is directly contrary to the one that prevailed in the French Revolution and also in early 19th century constitution-making episodes in France and I'm sorry, in Spain and in Latin America. That contrary view, the one that prevailed, was usually expressed through the concept or theory of national sovereignty, which was sort of contrasted with the Rousseau, with the idea associated with Rousseau of popular sovereignty. So here the idea is that sovereignty does not belong to the actual human beings that live in a territory, but to an abstract entity, a nation that has a will of its own, a will that could be different from and that should prevail over that of popular majorities. Now, that view had clear institutional implications. So if sovereignty belongs to the nation, then what matters is to authorize those best placed to identify the national will. And this is seen in practice very clearly, both in the 18th and 19th centuries in France and Spain, as well as in Latin America, where that view took the form in practice of constitution-making bodies comprised of educated men of property, elected under a limited franchise, because the idea was that these were the people who, the human beings, the selected human beings who were in the best position to identify the national will, which, as I said earlier, could be very different from the actual will of the majority of the population. Now, that view, the other view, the view that is associated with Rousseau, attributes, as I said, sovereignty to the people not as an abstract entity, but as referring to the actual human beings to which the law applies and who have, according to Rousseau, the right to participate in its making. Now, institutionally, that view for Rousseau and his followers required a popular assembly of all citizens or a series of primary assemblies convened in multiple localities. But when none of those options were possible, Rousseau maintained that a representative assembly could be convened. But, and this is the main point, when that happened, when you needed a representative assembly, those sitting in the assembly must be strictly bound by the instructions of those who elected them. That is kind of a very short summary of an idea that I developed in the first chapters or that I kind of developed, but just explain, really just making reference to the work of Rousseau, but also of his followers during the French Revolution and then later in Spain and Latin America. But and of course, if you the historians that early in the 19th century and late in the 18th in France and early in the 19th century outside France, that notion of binding instructions was abolished in basically every country that adopted a constitution. But anyway, following that approach of trying to rescue in that approach of the imperative mandate, one of the claims I make in chapter 10 is that even if there's no place today for the notion of binding constituent instructions or of the imperative mandate at the level of ordinary lawmaking, and even if the individual members of a constitution-making body are not seen as bound by the specific instructions of those who voted for them, a constituent assembly itself, as an entity tasked with the drafting of a constitution, should and can be understood as subject to an imperative mandate from the sovereign people, who, in the context of constitution making, takes the juridical form or acts through the electorate. And what I mean here is the following. So constituent assemblies, at least in contemporary constitutional practice, are usually convened by referendum. These referendums are a particular type of referenda in the sense that they authorize a change in the material constitution of the relevant jurisdiction, so a fundamental constitutional change. And in that sense, they are different from what may be called constitutional referenda. So referenda that are sometimes included just as a technical step in a process of constitutional amendment, and are probably better described as constituent referenda, which one would imagine would also involve a higher level of informal mobilization. So that type of referenda usually involves a question like this. Do you want to convene a constituent assembly for the adoption of a new constitution. If that question is answered by the majority of the electorate with a yes, then the relevant entity, I argue in the book, becomes bound to adopt a constitution. That is to say, the Constituent Assembly becomes bound, legally bound, to create a document or to draft a document that meets whatever criteria determines what counts as a constitution in the society in question. For example, it must create or draft a document that recognizes rights, that separates powers, and that establishes a democratic system of government. As I said earlier, the mandate to create a constitution does not include by itself an authorization to exercise other powers. So an authorization to exercise legislative, administrative powers, etc. Now, a referendum question could be more specific than that. It could do more than simply ask whether do you want an assembly to draft a constitution. For instance, both in Colombia in 1990 and in Venezuela in 1999, the referendum question did not only refer to constitutional change, but actually to the kind of constitution that should be created. So, for example, in 1999 in Venezuela, the referendum question stated the following. It said, so do you convoke a national constituent assembly with the purpose of transforming the state and creating a new juridical order that allows the effective functioning of a social and participatory democracy? Now, that type of question, regardless of the question would be, yeah, but what does social and participatory democracy mean? But leaving that aside, the point is that that type of question includes a more specific mandate, a mandate to adopt a particular type of constitutional content. And that mandate, I think, should also be understood as binding. And this means, I think, that a decision of a constituent assembly directly contrary to the mandate could be, for example, susceptible of being challenged in a constitutional court. After all, what constitutional courts are normally called to do is to protect another mandate, which is the Constitution itself. And in fact, this is the way in which constitutions were sometimes presented in 19th century literature as general mandates from the sovereign to the constituted powers. Now, the conception that I have just described has been considered but rejected by some courts in the Latin American region, and perhaps also by some courts in other regions that I do not know about. Now, Latin American courts in places like Colombia and Venezuela have expressed once and again that constituent assemblies, by virtue of having been called to exercise constituent power, are sovereign. So they actually say that sometimes explicitly. And that conception, even though generally presented as based on basic democratic principles, so the principle of popular sovereignty, is in reality a continuation of the national sovereignty approach, which I referred to earlier, and which is entirely compatible with an assembly that, like a sovereign parliament, can form a will independent of or even contrary to that of the electors. Interestingly, and with this I close, it seems that the confusion between sovereignty and constituent power was understood and is being left behind in the constitution-making process underway in Chile. So if you look at the official documents related to that process, you will find no mention of the words constituent power or constituent assembly. The drafting entity, for example, that was already authorized authorized to be convened. So the members of the assembly haven't been elected, but they will. That entity was not called a constituent assembly, but a constitutional convention. And I think that the reason for that avoidance of the use of the word or term constituent power or constituent assembly is precisely to avoid a sovereign constituent assembly as the one that other Latin American countries have experienced. In fact, the enabling rules of the constitution-making body in Chile which were inserted as an amendment to the current constitution, explicitly say, and that the assembly, and I'm quoting here from Article 135 of the current constitution, that the Constitutional Assembly must not attribute itself the exercise of sovereignty or assume competences others than those expressly recognized by the enabling rules. Okay, so I think I'll stop here, and I'll look forward to your comments and discussion.
Thank you very much, Joel. That was really fascinating, and I think a very admirable job of summarizing key points from a book which traverses quite a lot of ground. I would like to just, before I open the floor to questions from our virtual audience, I would like to just make a few comments of my own and pose a question to you. So, I mean, there's lots that I really admire about this project of yours. As others have said, one thing it does is it draws attention to some things that are probably not paid enough attention to, at least in the Anglophone constitutional law, comparative constitutional law community. Some events for like the Cadiz Constitution of 1812, which was very influential, but not enough discussed, I think, by Anglophone scholars. For example, I think that the rehabilitation, maybe that's the wrong word, but the reinterpretation of Rousseau is really fascinating and vital. And so there's really a lot there that's quite admirable. The one thing I want to point to, perhaps as a kind of provocation to you, perhaps as a sort of gentle challenge, is a kind of attention in the project, because on the one hand, it is a sort of a history of an idea. It is a kind of a conceptual history, or you might even say a genealogy of a particular concept, and it shows the strategic uses of this idea by different actors in different times and places over the last couple hundred years, very much motivated reasoning using the concept of constituent power, motivated by the domestic politics of the time and place, and the vantage point of particular actors and what they're hoping to achieve by either using the concept or avoiding the concept, sort of deliberate omissions perhaps in some cases as well. So there's that aspect of the project. At the same time, the project ultimately hopes to advance a kind of constructive interpretation of what you believe to be the best account, to articulate the best account of the concept. And so one thought that occurs to me is, so first of all, is that even possible? I mean, is it not the case that you yourself must be also a strategic actor in some way with this concept, that you have your own substantive commitments, the sort of priors that you bring to this project in the first place, and perhaps that's, but independent of that, just for the sake of argument, let's say that you are a totally dispassionate scholar elucidating the concept in a universalistic sort of way. I guess my question would be, what hope is there though for anyone else to take it up in that way, when surely everyone will be looking for the interpretation that they find to be most conducive or favorable to the particular project that they're advancing. So I suppose I wonder if people will take your work, those that like the implications will seize on it. And do you expect your book to be used strategically, I suppose, is one way of summarizing my question.
Yes, thanks very much. Thanks very much for that. That's a really good question and provocation, I think. So let me tell you something about the something that happened was while I was writing the book was that I didn't plan to write that 10th chapter. Like the chapter that I just talked about, that wasn't part of the original. It wasn't even in the book proposal, I think. But what happened was that what I saw was that this kind of distinction that I was trying to make here, and this kind of conception about the relationship, not now maybe between constituent power and the law, but between constituent power and sovereignty, was sort of screaming out of the materials that I was reading. But I think you are right that must be because I have some pre-understandings and political commitments that sort of drive me in a particular direction and sort of focus on certain things. I think you are right about that. Now, in terms of the actual potential implications of the book itself, like real life implications, I really don't have any hopes of any, but I think if there's any way in which the book could contribute to some kind of to have any actual life implication, would be that the idea the idea that I was just discussing, that a constituent assembly once convened is a sovereign entity, that is an idea that is not only defended by those that at a particular moment in times want to justify an entity that claims all powers to be able to drive a particular political project that perhaps does not have the support of certain parts of the population, or even the majority of the population. Say right now, for example, in Venezuela, there is a constituent assembly like this, a constituent assembly that conceives itself as a sovereign entity. Now, so the problem is that conception of the Constituent Assembly as a sovereign entity is not only the one that is held by those who, say, right now in Venezuela or in other contexts, propose this kind of or defend this kind of assembly, but it's also the conception that the critics of the assembly have. Because the notion that a constituent assembly is a sovereign entity, that constituent power and sovereignty are the same things, is just generalized. So what this argument, I think, may do, I mean, in theory, is to give like a critical tool, maybe, that now if we want to criticize the actions of a constituent assembly, we don't have to say, we kind of we don't have to argue, say, against the theory of constituent power itself, which would be something very difficult to do because it's quite often embedded already, say, in Latin American constitutional history. But to say, no, actually, if you understand the theory correctly, that is not a sovereign entity. You are kind of going beyond what the same theory that you are supposed to hold presupposes. But of course, what I'm saying presupposes that people are rational and would kind of engage in this type of, I mean, rational people are rational, yes, but that they would be reasonable and engage in this kind of argument at this level in what are often really tense and polarized political contexts.
I have to say I was moved by the argument of the book myself, in the sense that I would be one person who would have been wary of the kind of vague metaphysical connotations or associations around the concept of constituent power, and your book has sort of moved the needle for me in this respect, in that I can see that a more concrete sort of tangible juridical conception of the concept is tenable. So it's moved the needle for me in that respect. I think maybe you undersell your own influence and the potential impact of the book. I think one thing that strikes me about, and you can correct me if I'm wrong about this, but constitutional law scholarship and practice in Latin America in particular is actually how interested in theory it is, in ways that I think would be surprising to some other places. Like, so for example, constitutional law and practice in the United Kingdom, I think has historically been, and to this day, sort of theory averse in the way it explains its self-understanding. But it doesn't seem to me strange in the Latin American context for people to refer to Alexi or Kelsen or Schmidt or maybe Colón-Ríos in their debates about these issues. So perhaps the book will have traction there in very real life, real world scenarios. So I will stop with my own sort of commentary at this point and open the floor to questions from our participants. So you can ask a question, all of you, on the chat function. If you have any questions, you can type them there. I will then field them and relay them to Yoel, and he will have an opportunity to respond. I'll take them in batches or as we go. Just waiting for people to type in at this point. If there are any questions. I know this question's been asked of you before, Yoel, but I wonder if your thinking on it has progressed a bit. It is the case that the concept has had more of an impact or more of a presence in some places than other places. And, you know, this could be purely kind of accidental, sort of accidents of history and intellectual networks and communities. So that might be the case. Oh, I should actually just correct. I have a question here, so I'll just pause that. I'll just pause that that thought there. From our fellow Anna Zajit, she says this was an interesting discussion. Thank you, Yoel, and to me, she was particularly struck by the discussion of the idea that the people can be different to the nation. Does this mean that representatives in a constituent assembly for a nation will act differently to representatives of the people? And do theories of representation have salience in this here? She is thinking of the distinction between representatives as delegates versus representatives as trustees, but other theories might also be applicable. And I also have a question here. If you can kind of hold that in your mind, I'll take another one here for you to consider. You can always ask me to remind you of them. From Professor Albert Chen, who asks, can you tell us more about what is the people, community, nation that is supposed to exercise sovereignty? So these questions actually are nicely, make a nice pair. So you can go ahead, Yoel.
Yes. Yeah, thanks very much, Anna and Albert. So the distinction between popular and national sovereignty is a distinction that is quite I wouldn't say common, but it's not unheard of, say, in Latin American constitutional thought, and in fact it's often you often see it in judicial in actual judgments where judges would say things such as we are organized, this constitutional order operates according to the principle of national sovereignty and not to the principle of popular sovereignty, or the other way around. And what they mean by that, and the origins of this distinction, they have to do with the idea that at one point, and I don't know exactly when, but this probably happened sometime in the 18th or 19th century, some authors, and I saw many works in which this argument was beginning to be developed, but I don't know what the actual origin of it is. People started to say, well, that idea that Rousseau had, and people that associate themselves with Rousseau have, that the people is sovereign, that idea doesn't really make sense, because it cannot be that the people is sovereign, because if the people is sovereign, then it means that children should have the right to vote. It would mean that women should have the right to vote. It would mean that immigrants should have the right to vote, and that everyone that lives on their territory should have the right of political participation. And this, mostly, of course, conservative theorists said, that cannot be. So it's not the people who is sovereign, but it's the nation who is sovereign. And the nation, as I mentioned very briefly in the talk, was conceived as a sort of as an abstract entity. So it's sort of it's not clear what people meant by that, but they would say things such as the sovereign is the nation, and the nation is different from it's an entity that is different from the many individuals that live in a territory, and it has a will of its own. And that will is always for the good of everyone. So that was the idea, that whatever the nation wills is for the common good. And in this way, actually, strangely enough, then the idea of national sovereignty sort of went back to Rousseau again. So some people say, yeah, the nation wills the general will, but originally it was actually a reaction, very much against Rousseau, or ideas like that of Rousseau. Then during the French Revolution, it was also important, that distinction between people and nation. And CS, for example, was a defender of the notion of national sovereignty against the notion of popular sovereignty, even though he didn't use the terms popular and national sovereignty, but he talked about the nation, not the people, and the context in which he usually emphasized that it was the nation who had the constituent power, because he talked about the constituent power of the nation, was in the context of discussions about the abolition of the imperative mandate. Because what he would say was, well, if the people have, I mean, he doesn't say this explicitly, but this is what he seemed to have in mind. If the people are the constituent power, then it means that that people who insist that electors have the right to instruct the members of the constituent assemblies of the constituent assembly that they are right, and that we that are here in the constituent assembly must follow the instructions of the people who elected us. And as you will remember, in the French Revolution, people who were sitting in the Constituent Assembly, which were first supposed to sit in the States General, they had with them instructions from their constituents, and there was a debate about whether the instructions were binding or not. And CS said, no, these instructions are not binding, because when we are here, what we do is not to represent the people who elected us, but to represent the nation. And the will of the nation may be different from that of the people who represented us. Now, of course, that idea of the constituent power or the sovereignty of the nation is much more consistent with things such as a limited franchise, for example, that the idea of popular sovereignty. So that's more or less what the distinction between people and nation was at that time. And then the way in which it is referred to now, say in Latin American judgments, is that whenever a constitution provides, for example, for binding referenda, some people would say, oh, so that means that the constitution is based on the principle of popular sovereignty, because it means that representatives are bound by the will of the people, and that the will of the people may be superior to that of representatives in the case of constitutions that, for example, allow the electors to repeal ordinary laws by popular initiative. So that's a situation in which you have like a superiority of the electors over the legislature, and then the idea is the legislature doesn't act on behalf of a nation that is superior to the people, but rather is a sort of delegate of the people, and the people can, of course, at any moment sort of say, no, I want to make this decision myself, and that decision will be superior to that of the legislature. Okay, so I think I extended quite a bit in that question, but I think it was couldn't resist it. It was a good question. Now, the question by Professor Chen, this is quite a very difficult question, right? So the question was, I think, how do we know who is the people, who count as the people? And I don't have an answer to that question, other than to say that to say two things, that in my work, I always try to avoid that question, which is maybe it's certainly a weakness of my work, but I try to avoid it, because it's just, if I kind of focus on it, I wouldn't be able to write anything, because it's quite a difficult question. And I think that what I do in my work is to assume that the people, or when I speak about the people, or the sovereign people, or the community, is just that everyone that is subject to the constitutional order. But that includes people that are normally not conceived as part of the people, like in most countries, like it would include, for example, immigrants. So I kind of work under a sort of expanded conception of the people, just for the purpose of just developing different theories and so on. But if one asks that question like directly, but who counts as part of the people, then I think I don't think the answer can be given by a theory. It's just really a political, it's just a matter of argumentation. So it's just a matter of a clash of views about who should count as part of this polity, or who should be included as part of this polity. And in discussions, for example, about secession, that's actually what goes on in a very kind of explicit way. Of course, politically, if you ask me, I would defend like a really expansive conception of citizenry, which includes everyone that can be included. But then, of course, in the context of secession, the question becomes, but what happens here is that there is a different people understood as a group of human beings that have a common good or a common interest that is common to them, but it's different from that of this other group of people. So in those contexts, it's a matter, as I say, of political argumentation. You have to try to show that in fact, your interest is different from that of the other group. And that's quite a complex question that I am afraid I cannot provide an answer to it, but that's the way I would approach it, I think.
Thank you, Yoel. I just wanted to make a correction to what I said earlier. It's the Q&A function, not the chat function, through which you may ask questions of the author. I have another question here for you, Yoel, from Leo Benavides, and I can't see the last part of his surname. Leo Benavides asks, how can a country invoke a constituent power when there is no procedure for the elaboration of a new constitution in the current constitution? Is it enough just to appeal to the abstract entity? I suppose referring back to this thorny problem of the people, is it enough just to appeal to that abstract entity we call sovereignty to solve this paradox?
Yeah, I think you can interpret that question in different ways. You could say, let me tell you what has actually happened. Because what has actually happened, say, in places like Colombia and Venezuela is sort of exactly what Leo describes, which is a constitution that does not contain a procedure that allows the convocation of a constituent assembly, a political context in which the ordinary institutions of government cannot agree on reforming the constitution in ways which seems to be desired by large parts of the population, and then a government which says honestly or not, but a government which says it's clear that the will of the majority of the population is to adopt a new constitution. The legislature is not willing to use the process of constitutional reform to allow for the convocation of an entity that is able to create a new constitution. So what I will do as president, and this happened, say, the classic case is Venezuela, but it also happened in Colombia in a slightly different way. The president says, I will appeal directly to the sovereign people, and I will ask the people through a referendum whether they want to convene a constituent assembly outside of the amendment rules of a constitution. The appeal there, I think you are right, is to the sovereign people, right? Because the people under this traditional conception is sovereign. The point that I was making, of course, is that once the Constituent Assembly is convened, the Assembly is not sovereign. The Assembly has just been tasked to exercise constituent power. But then what has happened in those countries, both in Colombia and Venezuela, is that courts have actually said this is actually fine. This is okay, because the amendment rule is there in the Constitution to regulate and limit the extent to which the ordinary institutions of government, the constituted powers, can change the Constitution, can reform the Constitution, but of course the sovereign people acting through a Constituent Assembly can adopt a new Constitution if they want to. And they usually make reference to or describe constituent power as unlimited, as not being bound by procedures and so on. But the problem is, and this is connected to what I was saying before, is that in doing that, they end up always kind of identifying the Constituent Assembly with the sovereign people. And in fact, an interesting, maybe not interesting, but a relevant fact is that, say, in Colombia, for example, the Constituent Assembly not only drafted a constitution, but adopted it. Right? The Constituent Assembly was sort of acting as if it was the people. So once elected, it just it adopted ordinary laws. It interfered with the work of the judiciary, in some cases with justification, but it just did it, and then just gave Colombia a new constitution without the need to referring back to the people. So in a way, you could say, oh, so that looks like kind of the national sovereignty kind of approach, yeah, and then in more recent processes, a referendum has been required, which sounds as if the idea is that the assembly is just an entity that has just the function of sort of drafting a constitution that is then ratified only becomes valid if ratified, but the reality is that while drafting a constitution, these entities start to do other things, which is part of the problem I'm trying to deal with, which is just adopting ordinary laws, interfering with the judiciary and so
on. While I think we have probably time for a few more questions if there are any, I was just going to probe a little bit more on this issue. Oh, I do have a question there. I will, okay, well, you can take my question and the question of Dr. Matthews together. So Dr. Matthews says, great discussion. Isn't there a difference between the people who are bearers of sovereignty and the electorate, or those who have the franchise? Doesn't your account of popular sovereignty, limited binding constituent power collapse the concept of peoplehood into the empirical reality of an electorate? That's Dr. Matthews' question. I'll let you take that now before I pose my own.
Yes, yeah, no, that's an excellent, a really excellent question as well. So you are right. The idea of the people. So in theory, it includes everyone. It includes even people who are not part of the electorate, because the electorate is an administrative construct. It's just, to be part of the electorate, you have to register to vote, you have to be a certain age, there are some residency requirements and so on. So the people is just like a much general concept, and that's probably not the best term. But the electorate is so the people could be like a political fiction. The electorate is like some sort of juridical entity that is completely regulated by law. So you are right, and that there's an important distinction there. What I do, the way that I try to deal with that problem, is to say that usually the electorate acts as a state organ. So the electorate is sort of, from a certain perspective, the electorate is just like an organ of the state. So it has a function, which is to elect members of the legislature. Sometimes the electorate is asked questions and it replies yes or no. So the electorate, usually it works as an ordinary organ of the state. It has certain functions. It doesn't work as a kind of as a sovereign, as an expression of sovereignty. But there may be certain situations in a context, say, of major constitutional transformation, in which the electorate somehow could be understood. And this is, of course, a very controversial idea that I cannot defend fully, but and may be connected, say, to what Ackerman calls constitutional moments, and other people have written about. But certain situations in which society is reflecting about itself, about its juridical future, about the type of constitution they want. And then when you have, say, a referendum, say the recent one in Chile, where a great majority of the Chilean electorate voted in favor of convening a constituent assembly, I think one could argue, and I don't fully make this, I haven't been able to do this fully, but it seems to me that in that case, it was what the electorate that voted in favor of, say, the convocation of a constituent assembly in Chile that would get rid of the constitution adopted under Augusto Pinochet. I think that in that context, the electorate was something more. It was more than an administrative entity or more than an organ of the state, and it was closer to the idea of a people. So it's sort of the electorate acting on behalf of the people, in the same way that we sometimes say, and the legislature sort of adopted that law in the name of the people. So sometimes the electorate, I think, can do that, and that sometimes, I think, is in moments of important constitutional transformations. I know that this answer is not a full answer, but that's sort of how I try to deal with that, which is an excellent question as well.
I think that the idea that it might collapse the concept of peoplehood into the empirical reality of an electorate could be a feature and not a bug of your account, if people wanted to take that direction with it. To return to the thought or the question I was posing about the reception or the uneven, let's say, diffusion of the concept of constituent power across the world. So it does spread very fast once it's introduced and gets taken up by a range of people. But then we've noted, or you've noted before, that there are certain places which seem to be kind of only recently catching on to it. And so, I mean, this could all just be sort of, there could be no interesting story to tell about this, the journey of the concept around the world and why it takes off in certain places very quickly and not in others. But I wonder if you do have any, at least speculations, speculative sort of notions about what might explain this. Are there any patterns that you detect, or possible patterns that you apprehend in all of this?
Yes, that's that's an interesting question, and as I say, the most that I can do is speculate. One thing that I would say is that in places where Parliament has been conceived as a sovereign entity, the idea of constituent power, of course, is just doesn't really make sense. But not only that, but say in France during the 19th century and in Spain as well, those who defended parliamentary sovereignty in the kind of English style, they when they did that, they did that. I mean, in their arguments in favor of parliamentary sovereignty, there was always or usually an attack against the theory of constituent power. So the idea is that Parliament is sovereign and there's not such a thing as the constituent power. So it's not only an absence, but actually, at least in the 100 or 200 years ago, an active attitude against the theory of constituent power, because it was inconsistent with the notion of parliamentary sovereignty. But then now, as you say, the notion of constituent power has become much more popular. I remember when I started to do my PhD, which was about constituent power in Canada. I mean, that's what I was doing the PhD, not so it was about constituent power in general, but I was doing the PhD in Canada. I remember that every time I talked about constituent power, I first needed to really say what I was, people wouldn't have never heard this phrase, people would not, even constitutional law professors is like, what are you talking about? And then they would say, so you are talking about like popular sovereignty or about, they would understand the concept, but they wouldn't have used the term. Never heard the term. And in fact, if you look at, say, there was something interesting that I recently found, is that in English, in books, say, about the French Revolution, published, say, in the 70s or in the 80s in English, sometimes constituent power, that like pouvoir constituant, is translated as popular sovereignty. It's not, they don't even say constituent power. They just, you can find, there's this famous book, the Talmud book about the French Revolution, about Rousseau, really. They don't, and about CS, he never says constituent power. He just uses the phrase popular sovereignty, even though he speaks French, he read the originals, but yet he probably said, people won't understand. Now so now I think in the Anglo-American world, people, now constituent power has become much more like a much more common term, but only, I think, in academic discussions, not in you wouldn't expect, say, a prime minister or a judge, say, in the UK or in Canada, speaking about constituent power. It would be surprising. Now in India, they do speak about constituent power, but not in the same way, say, as in Spain or Latin America. I was recently reading the judgments of the Spanish Constitutional Court on the attempt of Catalonia of holding as a referendum on or about the secession attempt in Catalonia, and they are full of references to constituent power. In fact, the whole argument of the state and the judgment is usually based on the notion that the Spanish people is the constituent power, not the people of Catalonia. That's like the core of the argument. And the same in Latin America. Now, why is that in Latin America and in Spain, more than in France, for example. In France, you have 19th centuries, but now, and you have more recent judgments in which French judges engage with the concept of constituent power, but it's not the same as at the same level or frequency as in Spain as and in Latin America. And one speculation, and that one could speculate that at least in Latin America, and maybe in Spain as well, it has to do with the fact that and this may sound controversial, but with the fact that Carl Schmitt's work was originally translated into Spanish really early on, like in the 1930s, it was already there, like 1931 or 1931, it was already in Spanish. And say even nowadays, constitutional courts in Latin America, they quote Schmitt as if there were no problem. They just another constitutional theories. They just quote Schmitt. Usually, they even define constituent power quoting Schmitt. Now, Schmitt's work, particularly his constitutional theory, which is the work in which he develops a theory of constituent power, was not translated into English into 2007, I think. And I think after it was translated, that's where I think there was kind of an explosion of work on this area, first in political science and then in comparative constitutional law. So I think that's what I would say. So again, I don't have this just mere speculation, but I think there may be something to those thoughts.